Of course, that's all in the context of talking about the regular Army and Navy. Does 12406 say the regular Army or Navy? Does it make any reference to the regular Army or Navy? To believe her interpretation, you have to believe, again, that the president's required to send in the regular Army and Navy before he's allowed to activate the National Guard. Only if the entire Army of the United States and the entire Navy, and in the modern context, our entire Air Force, including, I guess, ICBMs, our entire Space Force, our entire Marine Corps, our entire Coast Guard, only if all of that is incapable of conquering Chicago, only then can Trump activate the National Guard. That's her argument here. Whew. Let's get back to the opinion. All right. So 12406.2, this is where there's a rebellion or danger of rebellion. 12406.2 permits the federalization of the National Guard when there's rebellion or danger of rebellion. So who decides if there's a danger? Danger is forward-looking, right? You're making inferences from what you're seeing on the ground that a rebellion could in the future develop. So someone's making a judgment call about what could happen in the future. Who gets to make that judgment call? The president, commander-in-chief, or an unelected black-robed tyrannical inferior district trial court judge? Well, this judge thinks she gets to do it. She says rebellion's not defined in the statute. So the court, she means her, turns to sources indicating the term's ordinary meaning at the time Congress enacted the statute. And she's going to say that it requires, it's only a rebellion if it's overthrowing the entirety of the American government, completely skipping by every time the National Guard was called out to put down a rebellion that was always focused on some narrow aspect of federal government. She says it has to be something like the Civil War. Are we in danger of something akin to another civil war? The president would be entitled to great deference if the entirety of the federal government was at risk of rebellion. But it does not appear that Trump has come to that conclusion. Well, obviously not. No one's making that argument. The June 7th memorandum issued by Trump states, to the extent the protests or acts of violence directly inhibit the execution of laws, they form a rebellion against the authority of the United States. In this case, the immigration authority of the United States. In all the memorandum actually issued deploying the National Guard, the court does not see any factual determination by Trump regarding a rebellion here. She says this is a legal conclusion, not a factual one. He says the conduct on the ground constitutes a form of rebellion. How is that not a factual conclusion? She just doesn't want to be a factual conclusion. Because if it's a factual conclusion, she has to give Trump deference, according to the case law we already have. This court cannot find reasonable support for a conclusion that there exists in Illinois a danger of rebellion that satisfies a civil war standard, that this is another civil war. The unrest consists entirely of opposition to a particular federal agency and the laws it is charged with enforcement. That is not opposition to the authority of the federal government as a whole. There it is. That's her reasoning. Unless the rebellion or danger rebellion threatens to overthrow the entire federal government, it's irrelevant to activation of the National Guard. Insane. It's not what any prior activation of the National Guard requires. And let's scroll back up. Does it say that anywhere in the Constitution? Does it say rebellion or danger of rebellion against the entirety of the authority? Why is this not to any authority of the federal government? Because she doesn't want it to be. That's why. Then we get to the next, the third provision, where there's the president's unable with the regular forces to execute the laws. She's going to say he has to be entirely unable. First, let's talk about unable. In the 18 and 1900s, unable was understood to mean not having sufficient power or ability, being incapable, lacking in ability. A binary approach. Either you're able or you're not. Capable or not. So if you try 1,000,000 times and you're able to do it once, then you're not unable. You're not incapable. You did it once out of 1,000,000 times. Next, the meaning of regular forces. Several historical sources indicate the phrase regular forces was understood at the time of enactment to mean the soldiers and officers regularly enlisted with the Army and Navy, as opposed to the militiamen. Of course, that's all in the context of talking about the regular Army and Navy. Does 12406 say the regular Army or Navy? Does it make any reference to the regular Army or Navy? To believe her interpretation, you have to believe, again, that the president's required to send in the regular Army and Navy before he's allowed to activate the National Guard. Only if the entire Army of the United States and the entire Navy, and in the modern context, our entire Air Force, including, I guess, ICBMs, our entire Space Force, our entire Marine Corps, our entire Coast Guard, only if all of that is incapable of conquering Chicago, only then can Trump activate the National Guard. That's her argument here. See if I can find her just saying that, and then we can move on. Here, Trump has made no attempt to rely on the regular forces before resorting to the National Guard. Nor does Trump argue, nor is there any evidence to suggest that the president is incapable with the entire active service military of enforcing execution of the laws. No shit, Sherlock. No shit. If Trump were to send in every active serving military person, he can probably conquer Chicago and enforce execution of the laws. You're a genius. You're a genius. Let's see if this is... Oh, then she gets into some posse comitatus stuff. She says, I'm not really addressing the posse comitatus reasoning here, but then she talks about it for pages anyway. I'm going to skip it because posse comitatus and 10th Amendment do not matter if Trump is within his 12406 authority, and he is within his 12406 authority. Conclusion, she grants the TRO, and she enters that. We read that yesterday. Separate document. So that's it, folks. That's this legal genius that Biden put on the federal bench. President Joe Autopen Dementia Biden, or whoever was pulling his strings. And we got more super chats here. Member for 2 months. Members get applause. Can you explain to me how or why illegal aliens have constitutional rights? The Supreme Court has said some constitutional rights just apply to every human being within the country. Is that a question that should be revisited? I mean, we made that rule when we had you have to remember, for most of America's history, we had an infinitesimal number of even immigrants in America. We're told this lie that America is a nation of immigrants. It's not true. And I say that as someone whose family came to America as immigrants in the 1920s, from Italy, from Sicily. We did not found this nation. We were never even a majority percentage of the population of the nation. Through at least the 1980s, America was something like 85, 90% white European stock. And most of that stock was not from immigrants who came from Europe. And in those days, almost all the immigrants had come from Europe. The 1960s, Ted Kennedy, woman drowner, legislation that prioritized the third world over Europe for migration to the U.S. hadn't yet fully gone into gear, had its full terrible effect. So the immigrants that were in America were largely of the same culture as our founders, a Western European culture, religious faith, social expectations, worldview. That's why even that tremendously difficult task of assimilating migrants into another nation was possible only because they were so similar to begin with. Even then, the United States government had a very rigorous process of assimilation in the schools to indoctrinate these migrants and their children into being genuine, cultural, not just paperwork American citizens. America is not a nation of immigrants. America is a nation of settlers. Settlers. What's the difference? Immigrants come to a nation that's already established, has a geography, has a government, has laws, has a culture. Immigrants come to that, but that has to be created. And that's created by settlers, not immigrants, the settlers who came to the North American continent and conquered it from the indigenous people, conquered it, created all of this. There was nothing. For God's sakes, there was no written language. There was no rule. There was no dwelling over a single story in height. The permanent dwellings were caves, the few that existed. The settlers from Europe created all of this. That's what America is founded on. The immigrants, like my family, were blessed to be able to escape the fecklessness of Europe and come to the greatness that is America. And we made the most of it. My family's been very successful in America. But we came to a place that already exists, not a place that we created. We like to think we added value when we got here. I still like to think that. I'm certainly a cultural American, but I don't pretend that I was a settler here. So, in those days, in that context, where there's very few, there's almost no illegal migrants. And the migrants who have come were legal. My family came legally. We came through Ellis Island. It was under invitation, and we got here. We became naturalized American citizens immediately. But the percentage of illegal migrants was so small that when one of them ended up in a criminal court, a criminal prosecution, we just decided, listen, we're going to extend to that guy the same due process protections we give an American citizen. It just feels like the right thing to do. If we provide a lawyer to an American defendant, we're going to give it to this guy too. If an American defendant's entitled to a jury, we're going to give this guy a jury too. Was that the call that had to be made? Could we have made a different call? Could we have made a call that says, listen, you just get put in a trebuchet and launched back to Sudan. You're here an illegal immigrant. You just get sent to prison. There's no jury for you. It's just an administrative conviction. We could have done that. We just didn't make that decision. And because the numbers of illegal migrants in America to whom we were generously extending constitutional rights were so small, it didn't really matter. It wasn't a heavy burden. But now, of course, we have 90 million illegal migrants in America and another 90 million legal migrants in America. God knows the level of migration fraud those have committed. How many of them married their brothers to get a green card? So now the numbers are a problem, yes. And the favor you can do for one neighbor, imagine your neighbor knocks on your door and says, hey, listen, I'm having a tough time right now. Don't have much food in the house. Can me and my wife and kids come over and have a dinner with you? Share your dinner. And you'd say, yeah, of course, man. Come on in. Come on in. We'll make a little extra. No problem. That's an easy thing to do when the numbers are small. It's a little different when 90 million third world illegal migrant invading savages come into your community and demand every scarce American resource for free. Housing, healthcare, education, employment, social services, everything. Now it's a problem. As we used to say back when I was working in life sciences consulting for the pharmaceutical industry, when we talk about toxicity, in that case, toxicity of drugs in R&D, the poison is in the dose. Small quantities of a toxin could be inconsequential. But if the toxin builds up to a sufficient level, it's a problem.